this journey, there's
My name is Tilly. When I was 13 years old, I was diagnosed with a brain tumor in my right temporal lobe. I had struggled with focal seizures for a few years prior to this. We did multiple tests, such as an MRI, an EEG scan, and just a bunch of different types of tests to monitor my brain when I had these seizures. So July 3rd, 2017, I went in and I had brain surgery. They were originally planning to remove my hippocampus, but because I have two extremely genius, smart parents, they only had the doctor remove the brain tumor, which cured me from my epilepsy.
Tell me a little bit about the background about how the song came to be.
So this song, it's called Stepping Stone, and it was written by my mother. She tells me that this was just a God-given song, and she's not musically talented at all, but music is one of my passions, and so it fit really well. And so it kind of just came to her one day, and ever since, yeah.
Your mom said you came out of the womb singing, and that you are very musically inclined and love music, and that you needed an anthem. And I just think the words are so gorgeous, and I think your voice does sound like an angel. So Molly, welcome. Hi. Let's begin with you. Share with us and our audience some of the pitfalls and similarities when creating a business and in the creative field.
So let's start with the main pitfall that I think people begin their businesses with, and that is perhaps a little bit of too much reliance on folklore and what I will call internet lore about intellectual property matters. So let's talk about intellectual property. Intellectual property is an umbrella term. It actually covers 4 different types of legal columns, right? And 4 different types of legal precedents. Intellectual property covers trade secrets, trademarks, patents, and copyrights. For creatives, right, most creatives, especially in the arts and media and design world, are going to be living in the copyright world. So that's where we're going to focus our conversation here. And one of the things that is fundamental to all of intellectual property is this principle: he or she who creates owns, absent an agreement to the contrary. So, right, if you create it, the law presumes that you own it. And when I talk to kindergartners, they get this, right? Like, it's only as adults that we start messing this up, right? And putting in all kinds of other things about it. But, right, if you create it, you should own it. And that's where the law starts. But you can give it away and you can assign it away in a lot of different ways. And I think that's where we talk about our first big pitfall. And people, especially in the arts and media and design world, you are very creative, you're very collaborative. Mm-hmm. Collaboration is really difficult in intellectual property law because you kind of have to set up the rules of collaborating ahead of time, especially with regard to copyright. So the biggest mistake that I see people making is that they enter into a very creative collaboration and they don't figure out who's going to own what and who's going to protect what and how that's going to happen before they do the collaborating. One of my favorite stories in this one is that, there was a group that said, oh yeah, my brother-in-law designed our logo and we've been using that logo forever, but my brother-in-law designed it. Well, the brother-in-law divorced the sister and then realized that he owned the logo, so that the group ended up having to pay him in order to get the logo assigned to them, when if they had just set it out at the beginning, there would have been no subsequent payment. So, right, you need to set the rules of collaborating ahead of time. And as distasteful as it might be to say, I'm going to own this at the end of it, you have to do that. And what the other thing that someone will say to me is, well, oh, that's a work made for hire, because they've read something about work made for hire on the internet. And they don't realize that even if it might be considered a work made for hire, if you don't have an agreement documenting the fact that it's a work made for hire, it's not a work made for hire. And you don't own it. So you can't presume that you own it if you didn't create it. So I think that's one of the biggest pitfalls that I see creative people getting into. And I understand it, right? You want to get into the creation, you want to get into the collaboration, but you really do have to take that step back and document how you are going to operate after the collaboration happens. So, also in that, right, and one of the things about copyright is that it really only protects the expression of the idea. I think the best way that I know how to put this is if Jeremy and I were standing next to each other. Jeremy's a way better photographer than I am, but let's just assume that we were standing next to each other and we were taking the exact same picture of a night sky constellation, right? So we're literally, and maybe even we're standing on top of each other, right? Right, so that we have the exact same perspective. We each take a photo. The photo looks exact, right? Only an expert would be able to tell that there was a difference between the photo, right? So you have a photo that looks exactly similar to, the untrained eye, and yet there's two different copyright owners for that photo. Even because I took one and Jeremy took one. Again, he or she who creates owns. So there's a lot of times when you're in the creative world that, it might look like something is infringing, but it isn't. And then there's also a tendency in the creative world to borrow. And I truly believe that imitation is the sincerest form of flattery. However, in copyright law, imitation isn't allowed. You cannot copy somebody else's copyrighted work. And there is a fine line between inspiration and imitation. And those are usually the cases that make the news. I always like to use, there's actually two cases in the media over the last several years that talk about that. And the best one, I guess, is really Pharrell Williams and Robin Thicke's Blurred Lines. At the end of the day, it was determined that they borrowed 6 beats, 6, and but they evoked a feel of a Marvin Gaye song, and that actually got them held liable for copyright infringement, and they ended up having to pay out. So I think, right, again, imitation, inspiration, and infringement are very fine lines in the copyright world. And the internet will tell you that, you can take 10% of a copyrighted work and not get held liable for copyright infringement. I, again, talked to you about Pharrell and Robin Thicke because they took 6 beats and evoked a feel. And they got held liable. There is no rule in terms of percentages or what. In copyright law, infringement is based on a substantial similarity. And yes, substantial has some meaning, but it isn't a hard line of 10%. It can be 6 beats and evoking the feel. And, when you're looking at copyrighted works that are out in the world, it's very difficult to determine when something is in the public domain. Copyright law has changed over the years. And so it's very difficult to tell when something is in the public domain and therefore available for use. determining whether or not a copyrighted work is in the public domain is actually something you need to confer with an attorney about, because a lot will depend on when the copyrighted work was created and when the copyrighted work would then go into the public domain and how it was treated. So I think, right, borrowing from something that you think is in the public domain may come back to bite you in the butt. And we don't want that to happen. So the other thing that I think that was the second pitfall, is that, imitation, inspiration, and infringement are very fine lines. And then the final pitfall that I want to talk about is what I call the failure to register. So a lot of times people will not register their copyrighted works, or they won't register their trademarks, the brands that they're using to sell, because I don't know, maybe they think registration is too hard. Maybe they think the agencies are too difficult to deal with. And sometimes they don't know what to register, right? But really, for copyright, you can't collect damages and you can't file a copyright suit unless you have a registration. And ideally, you want to file your registration prior to somebody infringing you, or within 3 months of you publishing that copyrighted work. And for people who are prolific creatives, I understand, right? There's a business aspect to filing your copyright registrations because it does cost money. But at a minimum, right, a creative person really does want to think about their brand and registering their brand as a trademark. And you also want to think about how you can package up some of the work that you're doing from a copyright perspective and file those copyright registrations early. I recognize that it's difficult, but one of the things that a copyright registration in particular does for you is that it eliminates the need to prove how much you were damaged, because copyright law has something called statutory damages associated with it. And those statutory damages are per copy. So, right, if someone really copies your work a lot, that can run up the statutory damages quite significantly. And I think that's one of the reasons that it is absolutely worthwhile considering, a copyright registration. So some photographers, I'll use photographers as the example, right? Some photographers who are very prolific will put a copyright registration together of a series. When you're considering what to copyright in that realm, if you're very prolific, you really want to be careful about how much you put in there, knowing, again, that the standard for copyright infringement is substantial similarity. So let's say you put 1,000 photos in a copyright registration as a compilation, and someone picks one. While there isn't a percentage, right, that's associated, or a hard line, bright line percentage that's associated with copyright infringement, 1 out of 1,000 might raise eyebrows. So you want to be careful about how you're creating those compilations if you're very prolific. And I really do think that's something that you want to, talk to an attorney about, how that might look and how you might want to do that. With that, I think that's actually a perfect segue to Jeremy to talk to you about resources that Idaho has to offer to help arts and creative people in Idaho with legal stuff.
The advice about copyright is something that creative developers of any type should really have a handle on. Whether you're an artistic creative like a photographer, a videographer, a sculptor, or whether you're more technical creative like an app developer or a web developer, copyright can still be used to cover your creative outputs and help you maintain the commercial value in those creative outputs and maintain it for your business or for yourself rather than let other people take it. The copyright registration costs either $35 or $55. And as Molly said, it can be used to protect compilations if you have a good strategy behind that. it's a great investment. $35, $55 is a great investment if you plan on using that creative asset for your business at all, if you plan on disseminating that asset for any reason or asking others to do so, because then you know that you'll be protected and you have a much easier pathway to claiming back against an infringer if they actually do use your photo or your sculpture or your video or your website or app in their business. So it's a great investment, and it's a great thing to remember that that it's a benefit of you living in the U.S. that this copyright office exists. So how might you develop that strategy? How might you get to the point where you know, okay, I've got this copyrightable subject matter. I want to file a registration. Oh, okay, I've got this logo and this business name. I want to file a trademark on it. Some people are really savvy. Some people are needing more assistance. So luckily in Idaho, we do have some resources that are available for entrepreneurs of any walk of life and any educational background. And these resources will help entrepreneurs interact with these important federal agencies that allow for these intellectual property protections. So I'm just going to talk through a few of those resources. So as Stephanie mentioned, I work for the University of Idaho. I'm also a proud Vandal. I graduated from the University of Idaho College of Law. And so some of these resources focus on the University of Idaho. And the first one is one that I actually participated in when I was still a law student years ago. And today has a different name than when I worked in it, but it still serves the same business community, is the Entrepreneurship Law Clinic. So this clinic takes practicing attorneys that work at the University College of Law, and they pair them up with students who have an interest in developing skills around representing small businesses. And so you'll get the service of a third-year law student under the close supervision of a licensed attorney. And this advisor will help you develop a strategy around how to protect the basic intellectual property that is the foundation of your business. This program focuses mostly on copyrights and trademarks and helping people develop their business in terms of business formation documents and business registration. So they will register a trademark for you through the Entrepreneurship Law Clinic. You have to pay the fee to the USPTO, the actual fee, which Molly's organization, fortunately, gives a reduced cost if you're utilizing an entity like the university, or if you're a small business. To file your trademark costs less than if you're a large business or a large organization. So they give you a little bit of a break, but of course those fees are still due, so that little bit of cost will still be incurred by the business if you register your trademark. But the substantial cost of having an attorney advisor walk you through the process and develop your registration documents for you will be covered, or will be provided by the Entrepreneurship Law Clinic. They can also help you address just general questions about your business, about premises liability or other issues that you might encounter as a business operator or entrepreneur. In the same vein, the College of Law hosts the Patent and Trademark Resource Center, which is a collection of special resources and trained law librarians to assist accessing those resources, basically to instruct and empower entrepreneurs and business owners to conduct background intellectual property searches on their own. So what you would do with this tool is go in, you might have an idea for your trademark, and the law librarian will help instruct you on how to use the trademark electronic search system and other tools to discover whether your mark is registerable for your business or whether somebody else is already using it in commerce for their business. Another great resource is called the Patent Pro Bono program, also hosted in collaboration with the USPTO and the University of Idaho College of Law. This program does vetting of clients who might qualify for patent services from lawyers who want to give pro bono service back to the community. So these patent attorneys in the past had a difficult time sorting through the many clients who were requesting pro bono services from their firms. And so instead, the College of Law now sorts through those applications and helps partner qualified attorneys with projects that they might assist through pro bono services. These resources are especially helpful for folks that are getting their business set up and that their business might rely on that intellectual property foundation. These folks who are trained professionals can help get you set up with the right advice and the right strategy to make sure that you're leveraging intellectual property in a way that makes sense for your business.
I'd like to apply this question to you guys, just to apply some of these facts and knowledge that we've just gained from the both of you. So Jen wrote a song for her daughter, Tilly, who was going through treatment for a brain tumor. Jen asked a few friends to help with some of the music. Tilly sang this song. Other singers and musicians have recorded their version of the song. The song is now posted on YouTube. Can Jen still get royalties, and what is her first step?
So they wrote the song together, or did Jen write the song?
Jen wrote the song, and a few notes were added by others.
Okay. So this sounds like we're in collaboration land. And so I'm guessing that this group of folks didn't hammer out an agreement that outlined the relative contributions to the copyright claim, right? Okay.
Probably not.
Probably not. Okay. So what do you think, Molly? I think here we might have multiple contributors to the artistic work.
Definitely. And right. So copyright exists as a doctrine when you fix it in a tangible medium, right? So, if Jen wrote the sheet music for the most part and all of the lyrics, she would own the copyright to the sheet music and the lyrics. A lot would depend on how people added notes to that. If there was, a violinist who came up with their own, like, a harmonic melody that went along with the song, that violinist might have their own copyright, depending on how they agreed that this was all going to go. Definitely, if Jen did not file copyright registration, and she just allowed these other bands or other musicians to perform it at will, they would have their own copyrights in the performance. And Jen may not be able to collect royalties. One of my favorite stories comes from one of my favorite bands on this exact topic. So Zach Brown wrote Chicken Fried, one of my favorite songs ever. Like, if I'm in a Friday afternoon, I need a pick me up, I'm listening to Chicken Fried on the way home, I guarantee you. But he let another band record the song with this caveat. And he said, yeah, you can record the song, but I think the song is going to be really big, so you can't release it as a single. And you can only record it and put it on your album. Well, come to find out, this other band decided that that's exactly what they wanted to do. The record company told them that they had to release Chicken Fried as a single. They released it as a single. Zach Brown sued them, pretty much against the advice of everybody in Nashville, because he was not a known name at the time. And he sued them and said, you agreed that you were only going to put this on the album and you weren't going to release it as a single. He won. And then Chicken Fried started Zach Brown's career. And he is an amazing creative. He is absolutely fantastic. But one of the things that he is absolutely savvy about is copyright. And it worked out very well for him. So, yes, a lot would depend on how the collaboration was done, how Jen allowed all of those other musicians to, record, and whether or not she put any restrictions on their recording the song, like Zach Brown did. And then, again, how she allowed other people to collaborate with her and add to the song. So, if she didn't do anything, she might be, what's the technical term we want to use for that, Jeremy? Is that SOL?
Up the river without a paddle.
It's SOL. She might be a songwriter out of luck.
Yeah.
Okay. Well, I would love to also hear the other side of it, because as creatives, so you have copyright and you have copy left. Oh, here we have
Yeah, so I think here, the multiple artists that contributed to the creative work here, each of them is an artist, each of them is a contributor, and each of them brought new creative subject matter to the song. And whether they fixed it in a tangible medium by writing the sheet music as maybe the original author did, or by recording it using their phone sitting next to them as they played it over the top of her performance, either way, they've created a new creative input to that song, and they have additional independent rights in their creative input that are independent from the rights of the original author or the originating creator, let's say. So here I think we do have an instance where we have multiple creators. I think we have an instance where they did not agree to a royalty share at the beginning. And so they each have a claim to the creative work and the element of the creative work that they contributed to. So here I think we're in a little bit of a slippery situation where rightly, either the originating contributor might claim that the song that she wrote in the first instance is her creative output and that the others are infringing on her creative output by performing it with their subtle additions. And the new creators who have put their additions on the top would say, hey, my creative input on top of the background that she wrote is substantial enough, is new enough and different enough that I qualify for my own right in the whole new creation. So I think it could cut both directions. I think people have a pretty good foot to stand on in terms of arguing either way. But it would boil down to questions around substantiality of the creative work, what was new versus what was borrowed.
I think that there's a community of folks that say, you know what? I want to share my music with the world. I don't care about copyrights. I do want to have attribution. And whether I'm creating a game, a video game, a virtual reality game, augmented reality, I want to put this in the public's hands and allow them to continue to build and build and build upon what I've shared with them. However, I want them to give attribution to it, to me as a creator, but they can be part of that creative process. Can you talk to that?
So that's the agreement that we've been talking about. So anytime that you're talking about putting something, whether it's open source software or whether it's putting music out in the world, right, you would accompany that with some sort of license agreement that says you can use this, and please don't quote this as contract language, but right, you can use this however you want, just as long as you give me attribution to it. There's a lot of licenses in the software like BSB or I'm spacing on some of the other ones. But there are a lot of ways to do that. And if that's your choice as a creator, but what you don't get to do is to say, I want to donate this to the world and then later come back and say, I want royalties for it. You make that choice when you assign it out and when you sign that license agreement or put that license agreement into the world and say, all I want is attribution. You don't get to come back and say, well, now I want royalties.
Yes, I understand.
Right, because you've already given it away.
Yes.
Right. You've already given it away.
Yes. Gotcha.
Yeah.
Jeremy, is there anything else you want to add to that?
Yeah, that's a great point about you make the decision once, basically, and that is true for each new creative output. So if you decide in one instance that you want this app that you developed yesterday to be open source, and then you develop a different new app tomorrow and you want to charge money for that app, fine. You make the choice for each creative output, and that's your choice as the creator, absolutely. So at the university, we grapple with these questions sometimes, and we do release certain software and certain creative outputs as open source. And the license that Molly talks about can be as short as a couple of lines long. And some of these open source licenses literally are just a couple of lines long. It's not the kind of agreement that you think about signing and returning back to a party. It's the kind of agreement that says, if you download this, you're going to agree to these use parameters. And those use parameters are typically included in the actual code itself that you download. So it can be a fairly simple system to utilize as long as you understand that there are certain decision points that you can't walk back on.
And one of those decision points might be when you signed up for YouTube. So when you sign up as a user for YouTube, you signed a contract. And so you need to go back as that YouTube user and figure out what you gave away. In certain instances, there are some social media sites that will say, if you post a picture on X social media site, the user agreement says that you are granting either an unlimited license or a limited license or something else to the social media site for reproduction and for replication. You may also be guaranteeing that you are the copyright owner of that particular photo. Which, look, when I'm taking pictures of my pretty puppy, that's one thing, because I know I'm the owner then. I took the picture. But, if this is a picture that my friend took of my puppy and I'm publishing, but I'm guaranteeing that I'm the owner of that, we're in a sticky wicket then. And so you really want to be careful about what you signed with respect to that social media user agreement.
Mm-hmm.
And two, those, and a tiny additional point is that those apps might also make claims that depend on the way that you interact with their services, such that if you take a photo and you are the original copyright owner, but then you upload it to their app and you use their filters or their software to change it, sometimes that's the trigger for them to make that copyright claim. So yeah, you got to be very careful.
Thank you, Jeremy. Thank you, Molly, for your time today, sharing all of your resources with our creatives out there, and just so much to think about. And I think that I learned a lot around imitation, inspiration, and infringement. I love that we have the University of Idaho and the other Idaho's in universities, Boise State University and Idaho State University, that can help people navigate through this process. And so with that, we are signing off. Thank you.